So I just don't think it could be written neutrally.
I thought I had understood you to respond to the Chief Justice before your colloquy with Justice Alito that if there were an independent and adequate state ground, if they had such a rule, then it would be barred. Is that right?
If there were, what's the
if the state of Arizona had an independent and adequate rule that it's consistently followed, then your claim would be barred.
If there truly was one, these are three reasons why.
No, I understand, but you can see that there's a world in which Arizona wouldn't have to supply this.
Correct.
And in fact, the federal district court found this argument procedurally barred under 2244, right?
Mr. Justice Gorsuch, I don't think that has anything to do with it. There they found that there was.
But it's plausible that it could be procedurally barred.
In federal habeas court, maybe there's a federal habeas barrier. We don't think that there is, for reasons our brief explains.
Well, but 2244 speaks of requiring a decision of this court to be declared retroactive by this court.
Well,
and the district court found that there was no such decision in this case.
Justice Gorsuch, the district court is a totally separate proceeding.
I understand that. I guess I'm just wondering how we can fault Arizona for having a rule, if it were consistently followed, that would effectively parallel the federal rule.
Well, Justice Gorsuch, I don't think that whatever is going on in the federal habeas bears on the jurisdiction of this court under 1257. They're two separate proceedings. And to answer the question presented, which is simply whether or not there's an adequate and independent state ground from the petition of from the Arizona Supreme Court, I don't think matters to federal habeas. With respect to that, look, we don't doubt that there could be waiver arguments that are available even from review of a state's post-collateral review proceeding. We're not questioning any of that. What we're saying here is that Cruz did everything right. He preserved his argument at every turn, starting from trial and when he was convicted, and then.
Well, what do we do about that? Actually, that raises another point in my mind, which is the trial court, admittedly not the Arizona Supreme Court, but the trial court here did find that your client failed to present a jury instruction along these lines to preserve this argument. And so even if we were to find for you and say there was no independent and adequate state bar, all we'd be doing is sending it back to the Arizona Supreme Court to find that he waived the argument in the first place, and we've accomplished very little.
Well, that was just wrong under this court's decisions in Simmons and in Lynch. So in Simmons—
But we wouldn't be able to review that. That would just be a waiver under state law. And if the Arizona Supreme Court were to affirm it, you think it's wrong, you could appeal, I understand, but that would be all state law, right?
No, Justice Gorsuch, that's exactly a federal question. This court in Simmons and in Lynch said—
Waiver's a federal question?
Well, the reason that they're claiming waiver, which is you didn't seek a jury instruction,
right.
Here Cruz sought to present evidence about his parole and eligibility, and at pages 163 to 167 of the plurality in Simmons and at 175 to 179 of Justice O'Connor's concurrence, it says either suffices, seeking evidence of parole and eligibility or a jury instruction. And definitely it can't be the case that you couldn't or a federal court couldn't review that. That is a purely federal matter.
Last question, I hope. In Beard, Justice Kennedy said that when we approach the question of the consistency of state courts' decision-making in this area, interpreting their own laws, their own procedural rules, 32.1, whatever it is, we have to give those state Supreme Courts some leeway to develop their own jurisprudence that we would expect to allow ourselves and other federal courts. What's your response to that?
We absolutely agree with all of that, Justice Gorsuch. The test has always been firmly established, regularly followed. That's what Justice Kennedy says in that case. That's what their own brief in opposition admits at page 11 is the standard. There is no way you can get to regularly followed and firmly established, this application of the law concept. That's entirely hair-splitting. And if you want to know just how hair-splitting it is, because you mentioned the trial court proceedings, look at what these prosecutors said to the trial court. This is joint—
on my question, you agree with Justice Kennedy and Beard?
Yes. I mean, so you could go, so as long as it's predictable, provides fair warning, and firmly established, absolutely. This is the opposite. This is what the prosecutor said at Joint Appendix page 307. Quote, Lynch overruled a well-established line of Arizona Supreme Court opinions holding Simmons did not apply in Arizona. It was an unambiguous rule that the defendants were not entitled to Simmons instructions. That's what they said then. Take a look at now what they're saying at red brief page 1. They say the exact opposite. opposite. They say Simmons was well established.